Following our series of explaining case decisions, today we're going to talk about a memorandum that was issued in April 2016 because it's going to become very relevant in people are going for L1As and even going for EB1Cs. Although this is particular to L1A, some of the logic and can be used from this decision to be used in your cases for EB1C, which is something right now a lot of people will be willing to do with the way things are going in the economy. This is Shaparali from the Shaparali Law Group. We have been practicing immigration law now for almost going on 19 years. Actually, I did, but the law firm has been here almost 18 years. And we would like you to subscribe to our channel and click on the notification button. And please share and like and comment. We want to see your comments. I want to hear what you think because I'm trying my best to pass the message. I used to do a lot of radio, but now with so much work and with all the issues happening with the layoffs, etc., so I'm not going to do that much radio. So the YouTube will be my way of communication. So today we're going to talk about this memorandum, matter of Z-A, adopted in 2016 and April. It's an AAO decision, the Administrative Appeals Office in 2016. And this, for those who don't know, whenever you get a case denied, especially for example H1B, etc., you can do you do an appeal, which mostly a motion to reconsider, and oftentimes this is taken by the Administrative Appeals Office, and it also can become actually an accepted, adopted decision. Not all decisions are adopted decisions, but some are, and this one is a very interesting one because it relates to all the concept of functional manager, although it's more like the most important part that they will mention in there is a part of what they have to look at when deciding if someone is in a managerial role. As you know, to get an L1A, you have to be in a managerial role and you have to offer something, and you have to also be a managerial role abroad and then come here to do the managerial role. But what happens if you don't have any employees here? A lot of things are doing virtual now, and it used to be that the concept of having a bunch of employees around you that reports to you was very, very important. It's still important, by the way, but this case is turns it a little bit upside down. So in this case, there was a Japanese gentleman who applied for an extension of L1A, and this was denied, and it went up because the reason for the denial was that he barely had any people working here. The office was not operating the way an officer of immigration will see, as he's in a managerial role. So this is what the Administrative Appeals Office reversed the decision, the denial, and this is what they say. Number one, while an L1A function manager may use his or her business expertise to perform some operational administrative tasks, he or she primarily must manage essential function. Okay, so for those who are in the field, they will understand what they're talking about here because now with technology and remote working, you don't have to have a bunch of people sitting around you. You can pretty much have them work remotely, but then everything is centralized to you or to someone else, and that person becomes a functional manager. This is why, number two, they say to determine whether someone has a beneficiary's job duties will be primarily managerial in nature. Remember the word managerial here, okay? That's where a lot of people get confused what it means. It means something deeper than just managing. It has to be reporting, control and dominion, etc. So an adjudicating officer must consider the totality of record. Okay, that's a word that you want to look at. Totality of record and the relevant factors. Okay, so including but not limited, of course, to the nature of the scope of the business. For example, in IT field, a lot of things can be done remotely. You don't have to have a bunch of people sitting around. Of course, if you're doing construction or things like that, you might have people on the site. That's different. And then you have petitioner organizational structure, then you have staffing levels, and also the beneficiary's position within the organization and the scope of their authority, the work performed by the staff and the employees, including whether the employer, including the whether the employees relieve beneficiary from performing operational administrative duties and other factors, of course. Then number three, when staffing levels are considered in determining whether an individual will act as a manager, an officer must also take into account relevant evidence of record concerning reasonable needs of the organization. Okay, so let me go a little bit on the factual background and then I'll explain to you what all this means. In this case, in 2011, the petitioner, the company, established a US subsidiary in the United States. And the main company, the parent company, was located in Japan, and they were trading almost $900 million. Okay, don't look at the figures. Doesn't mean your company has to be trading that much to be able to fall into that. So the parent company owns a research and development laboratory, 7 factories, and 9 subsidiaries located in Japan and 5 other countries. I think they have few in Singapore, etc. And in this case, going to the next line, the beneficiary, he was selected as head of the company. Petitioner is a company, by the way, in the United States operations, right? And what happens there is he reports to a general manager who basically controls all the international departments, something very common when you have multinational. And he was directing he was directing the company's financial, legal, trades, administrative, sales, etc. And he planned goals. He was reviewing, monitoring sales. So he was pretty much controlling the entire operation. But he didn't have any staff really. Okay, with regards to staffing, he had a sales manager and a specialist in the office. That's pretty much it. And the rest he was getting them from outside. The support was coming from outside, international department, and that's where USCIS kind of saw that this is not really a manager because he doesn't have that many people. So the USCIS, when they called the directors, the USCIS denied this petition that they didn't establish that it will employ a beneficiary in a managerial role under 101A44A. Okay, so the USCIS, I'm changing the word director for people to know, they say they don't have an organizational structure. And you know, if you look at things, and that was 2000, back into 10 years ago almost, right? When they were denying people because we're kind of in a transition from, it was pre-COVID, of course, transiting the entire system into virtual. It was still physical. You had to be in the office, have the sales. You know how it is, and now things are changing. Even if you look at Facebook, etc., they're letting go of their buildings because everybody is working from home. Not everybody, but many people. So based on that, they look at the organizational structure and they denied the case. And actually in this case, of course, the petitioner appealed the case with the AAO, and they say that he was doing the function of a manager. That's why we call it the functional manager, right? And this case should be reversed. And indeed, AAO reversed it. And I'm not going to go how they did it because that's how the law operates. It was an appeal. So now the law that applies to this is section 101A15L. Okay, that describes the L1 classification. It's very interesting. You should read it. An alien who within 3 years preceding the time of his application for admission into the United States has been employed continuously for 1 year by the firm or corporation or other legal entity or an affiliate or subsidiary and who seeks to enter the United States temporarily in order to continue to render his services to the same employer or subsidiary or affiliate thereof in a capacity that is managerial, executives, or involves a specialized knowledge. Okay, we're going to break this. This is the entire, pretty much the entire law. Well, of course, there are case law, etc. That really governs the L1A, and you have also you can use this also somehow to do the EB1c. So first, the first element, managerial role. I'll go backward. The second element, within 3 years, 1 year, and it says continuously. Sometimes people ask me, well, can we break it like 6 months, 6 months? It does work, but it's a lot more difficult. But if you see the law here, it says continuously. What is continuously means there was no break, but that doesn't mean someone cannot come to check on everything. But if they come for too long, they kind of break it and they have to complete the 1 year. But an argument can be made within those 3 years, you had to move back and forth, etc. So that's a different issue. And if you meet those requirements, then of course the company is an affiliate or a subsidiary. The three things are right there in the act: subsidiary, managerial, 3 years, 1 year, four things actually. Okay, so in this case, the issue was a managerial capacity, right? Basically, the government was not agreeing, the USCIS was not agreeing that this was a managerial capacity. So the court, well, the AAO came back and basically defined the managerial capacity, and it says someone who manages organization, departments, then second, supervises, controls the work of other professionals, and then if another employer or employer directly supervised, has the authority to hire and fire. That's another word which is very, very important. It's like a control thing. Then exercise discretion over day-to-day operations. That will make that person a manager. And this person, this gentleman, was actually doing all this. And but the organizational chart was not showing a lot of people, and the government denied. And that's where the functional manager rule came in. And this is what the AO said. If staffing levels are used as a factor in determining whether an individual is acting in a managerial capacity, shall take into the Secretary of Homeland Security shall take into account the reasonable needs of an organization, component, or function in light of the overall purpose, stage of development, organization, or function. So they're basically saying you can't just take the number of staff to determine if someone is in a managerial role. And that's a question that I get very, very frequently. People ask me, hey, I don't have that many. How many people I should have? Well, everything is basically a totality of circumstances, a totality of the records, etc. So basically, the EO came back and said something very, very, very good actually, because it's a changing world, and we saw that after all this with COVID, like everybody, many people could work from home, pretty much all of us. So that changed the whole dynamic. So now the analysis here is whether, of course, I did it a little bit up there. Is it a managerial capacity under that section of Law 101A44A, coded in 8 CFR? As part of, we must examine whether the petitioner basically, the company establishes the beneficiary will primarily manage an essential function of the organization. That's the question to ask. Is the beneficiary, the employee, going to primarily manage the essential function within the organization? If the answer is yes, you got it. Of course, you have to meet the other requirements. So the question that they're saying, what constitutes a function, is not the issue. What they're saying they're checking if the USCIS, when they analyze the case, they will primarily manage if the beneficiary will primarily, that's a candidate beneficiary, will primarily manage the function. They must consider the evidence presented, and that's where they have to look at all the the totality of the records, not just go with one or two. And this is the managerial capacity definition. There's, that's where they distinguish between personal manager and functional managers. And that's where the thing became big. And now we can use functional managers since then. But since a lot of people are still asking the question, so I am making this video. And don't forget to subscribe, like this, and comment. I want to get your feedback on this. And this is where we look at the managerial role. And after we look at the job duties, we need to look also what is managerial in nature. And that's what they're saying here. You have to look what is managerial in nature. We must consider the totality of the record, not just limit themselves to one thing, but the totality within the organization. And ultimately, when they look at this case, all the data in this specific case, they concluded that that this person is in a managerial role, functional manager. So there are a few case law which are very interesting here. I'm going to go with this case law next in another video, but it is the matter of Church of Scientology. There are a lot of cases from the Church of Scientology, by the way. The L1A employee duty must primarily at the managerial or executive level. Okay? An employee who primarily performs the task necessary to produce is not considered to be employed in a managerial executive capacity. And that's another case, Brazil Quality Stones Inc. versus Chertoff, explaining that the petitioner bore the burden of demonstrating the beneficiary was primarily engaged in an overseeing essential function of the business rather than performing it himself. So all those cases I'm not going to analyze here because it's going to get really a little bit too lawyery. But at the end of the day, the number of staff should not determine if you are going to win or not win that case. So you need to look at the totality of the circumstances. Now they are going to apply the law to the facts. Upon examination of the detailed position description of the totality of evidence, the petitioner has established that beneficiary's responsibility will primarily consist of managerial duties. So in this case, they found out it was managerial in duties, and then also this is the part, the interesting part, that in this case they found out that he was in that managerial duties. So I can go on and on with this case. It's very, very interesting because it changed pretty much the whole view of the L1A. And and ultimately, after they apply the facts to this case, the conclusion that if it is the petitioner's burden to establish the benefit sought, and in this case they found out is if he was required to do work as a in a managerial role, even though it was less staff, they could use that as a functional manager and ultimately grant him the L1A. And they reversed that decision for the better of a lot of people, and it was adopted. So now we can use it not only for L1A but for EB1c. Thank you for watching. We'll be back with another video on some more cases soon. Thank you. Anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions.